All right, we're going to hand it over to our next panel here. And just a reminder, if you've got your devices and things, turn them on silent so we can hear everyone in the room. And I'm going to hand it over to my colleague Nadia Anguiano to kick off this group. So.
Great. Thank you so much. Okay, this sounds like it's on. Hi, everyone, and good morning. It's so good to see so many familiar faces and also some new faces. Thank you for joining us for our panel on, and I'm going to already start with procedural fairness and upholding non-citizens' rights in removal proceedings. While my co-panelist is getting the all-important charger, we'll start with introductions. Hello again, my name is Nadia Anguiano, and I am an associate clinical professor of law and the director of the Federal Immigration Litigation Clinic here at the Binger Center. And I've asked all of my co-panelists to talk briefly about the work and how the work that we do and how it relates in particular to the session that we are in today. My clinic litigates primarily in federal court, every level, district court, court of appeals, and also to the Supreme Court on occasion. And I mention that because even though some of our work is not in the trenches, and I am always so in awe of the folks who litigate in immigration court, by virtue of the work that my clinic does, we see how the removal system functions or dysfunctions to prejudice non-citizens, and then do our part through litigation primarily to try to fight back against some of those issues. So that's where I come from and how I approach the work.
Hi, I'm Fatma Maroof. I direct the immigration clinic or immigrant rights clinic at Texas A&M School of Law. We do all types of removal defense and as well as federal litigation. And I'll pass it to Rebecca.
Hello, everyone. My name is Rebecca Schultz. I'm a senior staff attorney at the National Immigration Project. Years ago was a staff attorney at Mid-Minnesota Legal Aid and also a longtime collaborator with and fan of the Binger Center and of these two women up here. And at the National Immigration Project, we do a lot of things, but a lot of what I do is training and technical assistance for folks who practice immigration law and who are defending non-citizens in deportation proceedings. So we're sort of seeing on a national level some of the trends that have to do with procedural, maybe unfairness, and trying to help folks with how to meet those challenges. I'll leave it there. Happy to be here.
Maybe that's what we should have called the panel, Procedural Unfairness in Immigration Court. To give you an overview of what we plan to talk about today, I'll go through some of the background and really grounding our session in that notion of procedural. Now I'm going to just start saying unfairness rather than procedural fairness in immigration proceedings. And then I'll talk about some of the ways that we have been able to push back against some of that inherent unfairness through some discrete litigation surrounding the document that first initiates a removal proceeding, so the so-called notice to appear. And I'll ground it in some of the early successes or some successes that kind of litigation has had, and then talk about a pending case that's at the Supreme Court right now that hopes to build off of that to increase, again, fairness in the process of initiating removal proceedings. What you'll talk about, Rebecca, quick?
Sure. Mm-hmm. I will talk a bit about kind of an aspect of unfairness that comes up in the context of what's called prosecutorial discretions, what we're seeing lately and during the Biden administration in terms of folks not being given their day in court, folks who want to access permanent status who are sort of being shut down from that. I'll talk about that a bit.
And I'm going to talk a little bit about burdens of proof in immigration proceedings, which are a little different than you might think.
Thank you. So some of that background, and when I started, I said procedural fairness, but I think it's important to ground our conversation in, and I'm speaking a lot for myself right now, but this belief that it's really difficult to bring any form of fairness to a system that is designed and actually functions to prejudice non-citizens in the removal process. And so when we talk about some of this work and some of the litigation that we do, and mostly speaking for myself, I want to stress that it's not an endorsement of the system. It's not an endorsement of its foundations, which we could have, and we have had numerous panels on its racist white supremacist foundations, and also the overall notion that people don't have the right to live freely and move around in pursuit of their own dignity and their families, their own and their families' safeties. But accepting, I would say, where we are, I think it's important to talk about what it is that we can do to push back against that inherently unfair system. And so I want to talk about why do we keep saying that that system is inherently unfair and that it is designed to work against non-citizens. I mean, there's a laundry list that we can go through of just some examples, but particularly germane to the topics we'll be covering today. Just one aspect of the way that the removal system is designed is that there's very little accountability for the Department of Homeland Security when it violates any of the actual rules and processes that are set in place. So, for example, in the notice to appear context, for decades, the Department of Homeland Security was not following the law for what that case initiating document needed to say. But on the other side of that, the consequences for non-citizens, and there's little accountability for DHS when it does violate the law. Eventually, we got to the Supreme Court and we got some accountability in forcing DHS to follow the law. But on the other side of that, the rules are not the same for non-citizens, and there are extremely harsh consequences for any even minor failure to comply with a very harsh and very strict system. And germane to what we're going to be talking about today is this in absentia removal process, right? Where once proceedings get going, if the non-citizen even misses one hearing, and I'll go through some examples of how it is that a non-citizen may be deemed to have missed a hearing, it can result in automatic removal and then lead to a slew of harsh consequences in terms of future eligibility for relief or their ability to stay in the United States. Once proceedings actually get underway, there may be circumstances in which there would be reasons to terminate those proceedings or to put them on pause, meaning termination means that they're just over and the non-citizen may have the ability to apply for relief outside of removal proceedings. And administratively closed refers to this idea that the immigration judge can pause the proceedings to let potentially other eligibility for relief run its course. And in that context, regulations make it really easy for the Department of Homeland Security to terminate proceedings or to dismiss proceedings and to say, we don't actually want to prosecute this case, even when it actually prejudices non-citizens. And the immigration courts usually are limited, again, by law, to terminate those proceedings unless DHS joins in that request. So again, it is this very, it's this process that's so heavily weighted on what the Department of Homeland Security wants versus what might be fair or even desirable by the non-citizen. And then lastly, burdens of proof. Burdens of proof are incredibly important for the lawyers in the room and folks who litigate in all areas of the law, who the party that has the burden of proof can sometimes determine how the process, the outcome of the process. And in the immigration removal system, burdens of proof, again, are stacked against non-citizens and in fact are reversed from some other common areas of law where in the criminal context, usually the prosecuting authority has the burden to prove, not usually, the prosecuting authority has the burden of proof to prove, the allegations and the charges. But in the removal system, it doesn't quite work that way. So now with that super depressing picture, why are we here? Everything's bad and stacked against non-citizens. Some of what we want to do today is take perhaps a more optimistic view and say advocacy matters. And there are ways that within that system, we can push back and achieve some pretty significant wins. Although our process here, or excuse me, our session here is primarily going to be focused on litigation, efforts, I think it's important to take a step back to also name that sometimes litigation is not only not helpful, but can be harmful. And that's not for sure, not the end all be all of advocacy efforts. And in fact, non-citizens and advocates are having really great, or I don't say really great, but some successes in the non-litigation space, in particular through administrative reform. You know, when the new administration came to be, some policies of the prior administration were reversed in part through a lot of really creative and aggressive advocacy by organizations like Rebecca's, for example. I'm not actually gonna just for the sake of time, I'm not gonna go into some of those details. But now talking about some of those litigation successes and how it is that we try to bring some fairness to the system. Just as two examples, we in the clinic and nationally, we've had the pleasure of litigating around issues of repeated removal actions. So this notion that DHS, once DHS brings a removal proceeding against a non-citizen and loses, that should be the end of the matter. The non-citizen shouldn't be subject to continuous litigation on additional removal charges. But that's actually not what the agency believes. And we've brought some of these cases in federal court to push back against, what we call a second bite at the apple, that once DHS loses on its efforts to remove a non-citizen, that should be the end of the matter, and the non-citizen should have some repose. But instead, what DHS does is sometimes brings additional charges of removal that really were available to the Department of Homeland Security before, but they just didn't litigate. And so we've had success in arguing that some common law doctrines that apply in other legal contexts should also apply in removal proceedings. And we're really grateful for some of the scholarship from my colleague and friend Fatma in this space, that we're bringing these ideas then to the court and achieving success. Same thing with eligibility for relief and the defective notices to appear. Those are the cases that I mentioned in the beginning, where for many, many, many years, the Department of Homeland Security did not follow the law about what was required in this case initiation document. And very broadly, one of the things that must be on that notice to appear is the date and time of removal proceedings. It sounds kind of obvious. If you're being asked to appear or compelled to appear, you should know when and where to appear. But for decades, the Department of Homeland Security would not actually put the date and time of the removal proceedings. It put TBD. And so it created a system of just profound confusion and unfairness, where non-citizens didn't know where their hearing was, subsequently received other notices, but it was just a mess. And beyond the mess, it was what the law required, but DHS was just not really ever forced to comply with it. And so a couple of cases through years of litigation ended up at the Supreme Court, where the Supreme Court decided that that DHS had to comply with the law in that regard, that this notice to appear document had to be a single document that actually stated the time and date of the hearing, and that DHS couldn't send, that information in multiple notices whenever it wanted. So even through that grim process, there's been some success that that prevents non-citizens from being in vexatious litigation, and then having that initial notice of when and where they should appear for their proceedings. So again, moving forward, what do we do with some of those successes? What are advocates doing across the country to fight back? And this is just, again, an outline of what we're going to be talking about in our individual sessions. So in the context of this notice to appear litigation that I just mentioned, the next, or not next, but one of the ways that we are hoping to extend that litigation to bring increased fairness to the system is to litigate it in the context of in absentia removal. And I'm going to ground that and talk about what that means. In removal proceedings, as most of you know, the non-citizen is asked to come to court to answer charges of basically whether or not they should be removed from the United States, and the immigration judge will decide whether they're even removable, and then after that, whether they are eligible for any relief from that removal. But the reality is that the vast majority of persons ordered removed in the United States actually never step foot inside a courtroom. And there are a number of different removal schemes, expedited removal that you might have heard of, reinstatement of prior removal orders, or even removal orders that are just issued by the Department of Homeland Security itself. But then even in cases where there is a court process, where the case is initiated in the immigration court, a really substantial number of cases result in removal orders without any adjudication or any look at the merits of the actual removal case. And that's, for example, where the in absentia removal system comes in. So in absentia removal, the law says that non-citizens shall be ordered removed in absentia, meaning in their absence, if they fail to appear in court. And, you know, some of the rhetoric that's used around this is that non-citizens abscond, you know, they're just not showing up to the hearings, but the reality is much different. There was a really interesting study, an article that was written about in absentia recently that named some examples of these in absentia orders that are entered against non-citizens who, for example, might just arrive a couple of minutes late to court, or might be present in the courthouse, but not actually in the courtroom. And if you visit immigration court, it can be chaos, and it can be incredibly hard to find exactly where your actual court hearing might be, or even failure to being actually in the courtroom, in the courthouse, in the courtroom on time, but because of mental incompetence, you know, failure to follow the immigration judge's directives have resulted in absentia removal orders. And as I mentioned, the consequences are really quite severe. Once you are ordered removed in absentia, you basically lose your ability to contest your removal. And then if the order of removal is entered against you in absentia, you also lose eligibility or lose the ability to apply for certain forms of discretionary relief. So it's pretty serious business. Some of the positive things, or maybe like one of the ways that we have thought to and found to try to push back and really cabin that system of in absentia removal is, again, going back to what is it that the Department of Homeland Security needs to do before the immigration court can issue an in absentia order of removal. And the law requires that the Department of Homeland Security provide a statutorily compliant notice about the hearing. And what that means is the government has to provide that initial notice to appear that includes the date and time information in that single document. And then if that hearing doesn't go forward, then send a subsequent notice indicating the non-citizen of the change in that removal hearing. And to take a step back, what was happening before is the Department of Homeland Security is issuing or sending these notices to appear without any date and time information. And then whether months or honestly, sometimes years later, actually notifying the non-citizen of the date and time of that initial hearing. And this was leading to a system of many in absentia orders of removal, because non-citizens having gotten this initial document without a date and time, and then the date and time down the line, were just utterly confused about when and where to show up at the courthouse. And so one of the exciting cases that is at the Supreme Court right now, and I say exciting because we think we have a strong case. I don't think it's necessarily exciting to litigate at the Supreme Court. It's a scary Supreme Court right now. But based off of the prior wins that we've had in this space, we are optimistic, knock on wood, about the potential to extend those prior wins into the in absentia context. And the clinic that I direct is really privileged to actually be counsel for one of the non-citizens at the Supreme Court right now on this issue. And our client's name is Mr. Campos Chavez. So the case is Campos Chavez v. Garland. And that argues that, again, building off of the prior cases, that before the Department of Home, that before the Immigration Court can enter an in absentia order of removal against a non-citizen, it has to ensure that the Department of Homeland Security first sent that compliant notice to appear, that it can't send a document that doesn't have the date and time, and then down the line, send a different document that provides the non-citizen with the initial date and time. And so if the case goes the right way, which again, we are optimistic and hope that it will, it has the impact, has the potential to impact, thousands of non-citizens who are already subject to an in absentia order of removal, or maybe subject to an in absentia order of removal, even though in their case, the Department of Homeland Security did not comply with the law.
I can take it.
Now I'm going to turn it over, obviously, to Rebecca to talk about even some next steps or what might be on the horizon for NTA litigation.
So in light of the exciting Supreme Court case that clinic has going and sort of looking to what might be next, just a couple things I wanted to flag on this issue of kind of holding DHS accountable to complying with the law in terms of what the notice to appear needs to say. Two issues that the Supreme Court has not weighed in on, but that may be sort of litigated in the future. One is this idea, okay, well, if DHS files a notice to appear that is defective, that doesn't comply with the law, is that a reason for the court, the immigration judge, to just terminate the case, dismiss the case? The Supreme Court has not weighed in on that issue, but there's been a lot of litigation over the last maybe 5 years in immigration courts and percolating up through the system about that. And last year, we got a decision from the Board of Immigration Appeals, the administrative appellate agency, that said, yes, if DHS files a defective notice to appear, a notice to appear that lacks that information about the next hearing, the hearing's time and place, which is required by statute, an immigration judge it's a basis for termination. The immigration judge can go ahead and terminate the case. So that's helpful for non-citizens. But that decision also said, but it's in their discretion. They can also remedy it kind of however they see fit. And so what we've seen since this decision, which was called Matter of Fernandez last year, is that some immigration judges are terminating. Advocates are saying, look, the right remedy here is to terminate. DHS didn't follow the law, and if they want to, try again with a compliant notice to appear, they can. But in other places, we're seeing DHS doing all kinds of what I'll describe as creative things to cure or attempt to cure the notice to appear. And many immigration judges are permitting that, like the prosecutor handwriting on the notice to appear the previous hearing that already happened, the time and place, and saying, well, that's compliant. And the judge saying, sure. So this is kind of an active live issue. And a couple months ago, the Board of Immigration Appeals asked for kind of input on can DHS cure a defective NTA? And if so, how? And so I think we will be likely to see more decisions on this. And then depending on what the board says, probably more litigation in this area. Another kind of stretch from this Supreme Court issue. The Supreme Court, what they've been looking at in the previous cases and the one that Nadia is litigating, is this question of the notice to appear lacking the hearing time and place, right? That's one of the many requirements under the law that the notice has to have. And that's what the Supreme Court has sort of really been looking at. But of course, the law requires a lot of other things too, right? The notice has to have, there's a whole list of things that notice has to have. And so another question is, well, what about other defects? What if the notice to appear, for example, at the top of a notice to appear there's these 3 boxes, and DHS is supposed to check one. Either someone's an arriving non-citizen, they're present without having been admitted or paroled, or they've been admitted. And this matters because these boxes kind of signal what burden of proof scheme is going to apply, which Fatma is going to talk more about. And they also signal what charges would be appropriate. So what happens if DHS doesn't check a box? Is that something that someone could prevail on, either to get termination, or if they received an in absentia order, could they prevail in getting that case reopened based on this defect? The Board of Immigration Appeals said no during the Trump administration, but I think this is something, particularly depending on how Campos Chavez comes out, that could continue to be litigated, particularly in the context of in absentia orders. And I'll just mention one place where we saw a lot of this happening. During the Trump administration, there was a program that you might remember called the Migrant Protection Protocol, so-called. People called it Remain in Mexico. And it was a policy whereby they would, when asylum seekers tried to enter the US to seek asylum, they would be forced to return to Mexico. These are people who are not from Mexico, and wait in Mexico for their immigration court hearings, often in perilous conditions, often facing danger, maybe homelessness. And, tens of thousands of folks subjected to this MPP program received in absentia orders because they many times kidnapping, assault, rape, other reasons why they could not get to the port of entry in dangerous northern Mexican border cities for their hearings. And in many, maybe most, I don't know, MPP cases, DHS declined to check a box. I think it was probably the policy. So these folks all have in absentia orders with no box checked. And so I just mentioned that as a place where we may see kind of another place for litigation in this arena. Ooh, I'm trying to, here. All right, so now I'm going to shift to another topic and spend a few minutes talking about this other, kind of the other side of termination. So termination, right, is when the immigration judge ends the case. And for many people who are in immigration court proceedings, termination is the desired outcome, a good outcome. But I want to talk about sort of a flip side of that in the context of what's called prosecutorial discretion. And so basically, as folks probably know, prosecutorial discretion refers to this concept that law enforcement agencies, including immigration officers, have inherent authority to either exercise enforcement powers or not against a particular person. And in the immigration context, this can look like, are we going to arrest this person? Are we going to detain them? Are we going to pursue removal against them or not? And every presidential administration has kind of come up with their own policies about what should immigration prosecutorial discretion look like, and what do we want our enforcement priorities to be. And so in the context of the Biden administration, many of you may know there's been quite a lot of litigation around the Biden administration's policies in this regard, and there was a big Supreme Court decision earlier this year. But bottom line is that in the current moment, the policy is that there are sort of three enforcement priorities. And if you're not in one of those categories, the Biden administration will often consider prosecutorial discretion for somebody, which in theory is a good thing for a non-citizen. In the context of immigration court proceedings, the person who exercises that prosecutorial discretion authority is the ICE prosecutor, often called the OPLA attorney, Office of Principal Legal Advisor. And the ways that they might exercise discretion in a removal case would be things like dismissing the case, right? Agreeing to dismiss the case, or maybe stipulating that, yes, this person's eligible for the asylum that they've sought. Well, we won't fight that. Or there are many other ways, but those would be two of the key ones. And in the Obama administration, for example, a key way that the OPLA attorneys exercised their PD was through what's called administrative closure. They wouldn't dismiss the case, but they'd kind of put it on pause and let it sleep. And meanwhile, the person, if they had a work permit based on their case, would keep that work permit, all of that. The Biden administration is not very interested in administrative closure, and instead has really taken the position that dismissal is their preferred form of prosecutorial discretion. And they've dismissed, I don't have the number, but hundreds of thousands of cases. On the slide, I have this little chart. This is just from 3 months of 2023. This is 1 quarter of 2023. And you can see that there have been over 100,000 dismissals compared with 33,000 relief grants. And then 169,000-ish removals. So it's a lot. I mean, that is, and again, for many people, this is great. Like if you're already a lawful permanent resident and you get your case dismissed, you're back to just being in repose and being a lawful permanent resident. If you're a person who's undocumented, but maybe you don't have a strong claim for relief, or you just don't want to go through the risk and trauma and stress of an adversarial court process, this is a great outcome. But it isn't a great outcome for everyone. And I think the key fairness thing I want to emphasize is that the Biden administration's policy is that they are pushing for this when they see fit without even asking or finding out what the non-citizen wants and what their position is before moving forward. And so for some folks, for example, somebody who has a strong claim for relief pending before the court, all they want is to get to that final hearing, have their day in court, and hopefully get permanent legal status. Having their case dismissed pulls the rug out from under them and puts them in a position where they really have no possibility to regularize their status. For another large category of folks, they have had an application for some sort of status pending with the court for maybe years, and based on which they have an employment authorization, they have a work permit. Maybe they're the breadwinner for their family, right? And their whole family is relying on this source of income, and having that case dismissed without even their input, is hugely, problematic for that family. So I'll just say, again, the Biden administration has other options. And one that often is being pursued is, will you stipulate, look, my strong asylum case or my strong cancellation case, how about you not fight it? We're here for court. Might you just agree? And they've been very resistant to that and much preferring dismissal. I've got here on the slide, I'm not going to read this, but this is just to show you an example of what this motion looks like that the DHS is filing. My point is, it is literally this short. It is completely boilerplate often. It says nothing about the actual person or their circumstances of their particular case. And it really highlights or focuses on DHS's sole and unreviewable prosecutorial discretion. So this is sort of what this motion looks like. And it will also say, yes, we want you to dismiss, but we will feel free to file a new notice to appear at any point in the future that we feel like it. So this is kind of what this notice looks like. And they're relying on this regulation that is called cancellation of notice to appear, that basically allows, it lists a bunch of reasons why DHS can ask the court to dismiss a case. And the reason that the government is relying on under the Biden administration typically is the last one, which is if DHS decides it's no longer in the government's best interest to continue to prosecute the case because something has changed since they filed the notice to appear for the non-citizen. And again, for many folks, dismissal is good, but the idea that only one party's voice matters, that the non-citizen's position is irrelevant, is really problematic from a fundamental fairness perspective. And DHS will actually basically say that in their motion, that we didn't bother to find out what this person thought, even though the immigration court practice manual requires you when you file a motion to find out what the other party thinks or to try to do that. And again, going back to the rules and only one side having to follow them. So they don't bother to do that. And they'll say, we didn't bother because it would take time and that would be burdensome to find out what they thought. But also it's not relevant because this is our sole and unreviewable discretion to terminate this case. And so I'm listing here some of the things we've seen. We've done a survey over the course of the last year and a half when this has been going on of circumstances where this has happened. And again, this is unilateral, meaning they're filing it without seeking the non-citizen's position, and even when they know the non-citizen opposes it. So person pending application for relief in court, maybe pending for years and years and years. Maybe they have a work permit based on that pending application, which is going to disappear if the case gets dismissed. Having a strong claim for relief in court, sometimes relief that can only be heard in court, right? There's no other forum for that relief to be heard. Folks who have been separated from family members abroad who are in danger, who are desperate to get to their hearing, hopefully be granted relief and be able to petition for those family members to come to safety. Sometimes, and maybe not even infrequently, on the day of the merits hearing, right before the merits hearing starts, when everybody has prepared the case, people are traveling from far distances, witnesses have been prepped, reams of evidence have been filed, countless hours of preparation, seeking and achieving dismissal right there and then on the day of the person's merits hearing, which they've often waited years and years and years to get to. And another one not on the slide is, I have some colleagues who have examples of a person, let's say they were ordered removed, they challenged that and they were able to achieve reopening. So they won their case, they're reopening so they can get with the idea of now I can hear my case. These are folks who are abroad because they were previously deported. And then they seek ICE's help in getting back into the US so that they prevailed on their motion to reopen. They want to go and have their claim heard in court. And instead of helping them get paroled in, DHS files a motion to dismiss and dismisses their proceedings. These are folks who are now stranded abroad with absolutely no remedy. So these are some of the sort of the dark side, the problems with this approach, and again, sort of illustrating the one-sidedness with the system. And then just sort of where are we at with this? What's happening? Folks are challenging it. In some cases, we have seen immigration judges grant this motion without even giving the non-citizen their allotted 10 days response, right? There's rules that again say when somebody files a motion, the other side gets to respond. And some immigration judge have just granted it outright with the mistaken understanding that they have to grant these motions, which is not accurate. And we actually have a template that we've put out into the world about how to oppose these. Some people have successfully opposed opposition, so filed an opposition, and the immigration judge said, that's great, I'm going to keep this case, and then went on to prevail, right, and achieve immigration relief in court, win their case. And folks who have been unsuccessful have tried different options, tried different ways. I think this is still percolating, right? People who are appealing this, people who are dealing with this. I also end with just sort of one potentially promising administrative reform note, which is that in September, the Immigration Court Agency issued new guidance for immigration judges, which has some helpful language that I'm hopeful will make a difference in terms of how judges are looking at this. And it sort of stresses the idea that, first of all, that when an immigration judge is considering a DHS motion to dismiss, they have to take into account the non-citizen's position and their opposition, but also stressing that the immigration judge should focus on cases where the party wants to proceed to an adjudication of their relief claim on the merits. So leaving it with a silver lining of hope and turning it over to Fatma.
Thank you. Okay. Okay, so I'm going to shift gears just a little bit to talk about what DHS's burden of proof is in these proceedings. And as we'll see, there's not just one burden of proof.
Maybe I have a better angle.
Oh. Okay. Well, okay. So what you'll often hear is that DHS has the burden by clear and convincing evidence to prove that the person is a non-citizen and that they're deportable. And that's true, but only in a subset of cases. I know my arms are just too short. Sure, that would be great. Now I have a professional clicker next to me. Okay, so as Rebecca already showed you, the charging document has these three little boxes, right? And which box is checked actually makes a difference. But before getting into what those differences are, one thing that I want to flag is, there are implicit associations that we have between people of color and guilt. And one of the things to question is the way our immigration system is set up to reinforce those implicit assumptions. So unlike the criminal justice system where everyone knows you're sort of presumed innocent, until proven guilty, that's not really the case. And why is it that we don't have that basic presumption in immigration cases? And in an article I wrote, I'm arguing that the system is racially discriminatory by design, and that the reversed burdens that we see in different parts of the immigration statute is a way that's not, explicitly discriminatory or racialized in its language, but it effectively perpetuates these this type of racial discrimination that reinforces those assumptions or those biases towards people of color being guilty. Okay, next slide, please. Okay, so we actually have in those three boxes, among these categories, there's only one where DHS actually fully bears the burden of proof, and that's for admitted aliens, so people who've already been inspected and allowed into the country. And there, the burden is what I said before, clear and convincing evidence. For arriving aliens, which includes all asylum seekers who go up lawfully to the border and ask for asylum at a port of entry, for all those people, they bear the burden of proof. And it's actually an interestingly phrased burden. If I get to that slide where I can see it with my old eyes, it says clearly and beyond a doubt. Now, that's a burden I've never seen before in any part of US law. You've probably heard of beyond a reasonable doubt. Here, the reasonable is missing. Okay, it's clearly and beyond a doubt. That suggests that the burden placed on an asylum seeker in the US is higher than the criminal burden of proof that prosecutors have to carry, which is beyond a reasonable doubt. Here, it's just beyond any doubt. And that's, I think, actually an error in the statute. I think that was left over in the modern version of the INA. It used to be the standard to refer somebody from inspection to something called exclusion proceedings that we don't have anymore. And I think it was an oversight when Congress reformed the INA. What I find interesting is that has not been yet. I could find hardly any cases, no cases really interpreting this standard. So that is a ripe issue, I think, for litigation. Then for that third category of people who are in the US without admission or parole, there's a shifting burden. So DHS has the burden on alienage, then the burden shifts to the non-citizen to show lawful presence by clear and convincing evidence. But if the person is seeking adjustment of status, now we have that weird burden of proof again of clearly and beyond a doubt. Next slide. Thank you. So what does that slide mean? I'm sorry that looks really small, a little bigger up there. But you know, what's so interesting about that standard to me is, you know, the Supreme Court has talked a little bit about what standards of proofs mean. And one of the things the court has said is it reflects the value that society places on an individual's liberty. And so when we have a standard that's vague and undefined and even an error just sitting there in our immigration status and being applied every day to thousands of people, what value do we place on their liberty? Thank you. Next slide. And then we have one additional standard that I'll note, which is in applying for relief like asylum or cancellation of removal or whatever application is going to be filed. Now we have an additional standard of preponderance of the evidence, which is usually the standard in civil cases. Thank you. Next slide. So going back to sort of the racial origin of these laws, as I was looking into this, I kind of wanted to dig back to why is the immigration law, why do we have this flipped burden of proof? And it really took me back to the Chinese exclusion laws from the late 1800s. And a person of Chinese descent found in the US without a certificate of residence, this is the Geary Act of 1892. The act says was deemed and adjudged to be unlawfully within the US. So, and the Supreme Court noticed in a famous case called Fang Yuting, if no evidence is offered by the Chinaman, it's the Supreme Court's language, not mine, the judge makes the order of deportation as upon a default. So it's the Chinese non-citizens' burden, right? Not if they don't meet their burden, the court will order deportation as on a default. And in one Sixth Circuit case, the question arose, well, how do we even know if the person is Chinese? And the court said, it's a case of res ipsa loquitur. The tribunal judges by looking at the person. So that's where we were. That was 1904. And all of that is now ingrained, right? We may not have those same views anymore about Chinese individuals, right? But that's now built into the structure of the act. And this permeated all stages of the immigration process, not just the deportation stage, even at the investigation stage where the inspector had to get a warrant. In most cases, and I'll call it non-Chinese cases, because that's how the law refers to it, there had to be some burden of proof to get that warrant. In Chinese cases, the law said evidence is not required to support a warrant in Chinese cases. That's what the law said. And those acts were not repealed. The Chinese Exclusion Acts weren't repealed till 1943. So that's 68 years of normalizing reversed burdens of proof, which is why we don't even really question it anymore in so many aspects of immigration law. Okay, next slide, please. So there's burdens of proof at all these different stages, at the investigation stage, detention decisions, the removal proceeding itself, and then even in post-conviction relief when, say, a conviction has been vacated and somebody now wants to go back into their immigration case and try to get an order of deportation vacated. At the investigation stage, right, to this day, Mexican appearance can be a factor in a stop by Border Patrol, right? So that's one way that we have these very low burdens already for what we expect law enforcement to meet that would be rejected in any other in a criminal situation, but not in an immigration stop by Border Patrol. So if we move on to the next slide, please. When it comes to detention, we're seeing some positive developments in the law. We're seeing at least a bunch of circuit splits. So when it comes to the burden of proof for detention, and this is for prolonged detention. So the normal burden of proof on detention is on the alien, the non-citizen, right, who has to show that they are not a flight risk and not a danger to the community. And that's being challenged in different parts around the country. Where we've seen some positive outcomes is in cases where people are subject to mandatory detention. So they've not ever had a bond hearing, and they're being detained for a prolonged period of time. And they now, file a habeas to try to get out. And that habeas might be appealed to a circuit court. And the question is, well, now that they've been detained for this unconstitutionally prolonged period of time that may violate due process, right? Who has the burden of proof in this new bond hearing? Is it going to be the non-citizen or the government? And we have a circuit split on that now. Let me just look. I'm so blind that I can't see that, so I have to pull it up on my own slide. Okay. Yeah. So next slide, please. I think I may have been one slide ahead of us. That's good. So the first and second circuits right now have put that burden on the government, whereas the third, fourth, and ninth circuits have put it on the immigrant. And then we have a bunch of district court cases in some of those other circuits. Next slide. On vacated convictions, similarly, what the BIA has said is that if a conviction is vacated for a substantive or procedural reason, so there's some legal flaw in the conviction, that counts as being vacated for immigration purposes. If it's being vacated for rehabilitative reasons or because of immigration hardship, it doesn't even count. It still counts as a conviction, right? So we just ignore the fact that it was vacated. So then the question is, well, when a non-citizen is trying to reopen their case, say, because of a vacated conviction, who has the burden of proof about showing why the conviction was vacated, whether it was substantive and procedural, or on the other hand, rehabilitative? And again, we have a circuit split. The Ninth Circuit has said, sort of in a case, but not with a whole lot of analysis, that the government should bear the burden, whereas the First and 11th circuits have said the opposite, that the non-citizen, and so has the BIA. And normally for a motion to reopen, the burden is on the non-citizen, so that complicates that analysis as well. And by the way, these some of these decisions, like the detention decisions, are those are as applied challenges. So the circuit court decisions aren't necessarily going to be binding on everyone else because they're looking at sort of the individualized facts of the case and deciding if there's a constitutional violation or not. So we also see in vacated convictions a lot of errors by immigration judges just in analyzing who has the burden of proof, on whether it was vacated for immigration purposes. It should be whoever has the underlying burden of proof in the proceeding. So if it's a case where DHS has to prove deportability by clear and convincing evidence, and DHS is trying to rely on a vacated conviction, then DHS should have the burden. But even in those cases, we're seeing judges mistakenly place the burden on the non-citizen to show why their conviction was vacated. All right, next slide, please. Thank you. So another aspect of this to think about is it's not just that we've eroded the burden of proof in immigration proceedings, but also that immigration law erodes the burden of proof in criminal proceedings. Imagine cases where people have pending criminal charges, which is quite common. So they've been arrested for something, they're taken into custody, but then they're immediately put in removal proceedings before their criminal case is resolved. So they still have a pending charge. In those cases, if the non-citizen chooses not to testify about the arrest or the offense in immigration court, a negative inference can be drawn from that, right? There's no right against self-incrimination. Like you don't have to speak, but the judge can decide that you're something bad about you, right? They can decide you're not credible or that you're not telling the truth because you decided not to speak. So that person in that case has to either testify in immigration court to try to get immigration relief of some kind, asylum, cancellation, whatever it is. But if they do that, right now they're potentially undermining their presumption of innocence in the criminal case where they have the right to remain silent. And Linus, I think some of your work has really addressed some of this, and I definitely cited to your work in the article I wrote, and I'm grateful for your analysis on that. That's just one way that the burden of proof is undermined in criminal cases. Arrest reports come into immigration all the time, even though they're not tested in their reliability or anything like that. And so unproven criminal charges get used in immigration cases pretty routinely. We've also seen, and I'm not going to go deep into this third point because that would be a lecture in itself, but most criminal convictions are analyzed with something called the categorical approach. But there's a different way of analyzing convictions that does require looking deep into the facts of a case and the underlying circumstances, called the circumstance-specific approach. And when you start using that approach, you can often rely on facts that were never proven in a criminal case. So, for example, a deportability ground or removal ground having to do with drug offenses exempts marijuana possession if it's 30 grams or less for personal use. So the amount of the drug, whether it was 30 grams or less, is a circumstance-specific analysis, according to some courts, including the Ninth Circuit recently. But that may be something that was never proven beyond a doubt in the criminal case, but those facts will still be used in the immigration case. So things like that. All right, so I'll just conclude my last slide here. Sorry, if you could advance it. Oh, it is already advanced. I'm so blind. Okay, thank you. Why should we care about these reverse burdens? Obviously, there's the risk of erroneous deportation. There's the severe consequences of detention itself. There's also just a culture of admission in immigration court, which those of you who are practicing attorneys in immigration court, I would really think hard before admitting, conceding, question every burden of proof, question what the judge is assuming. Because I think, it's so ingrained that often we don't even stop to think about, well, why does my client have the burden of proof here? Should that be how it is? Is that something that I should reserve for appeal later on? And again, as I started out by saying, it reinforces these racialized assumptions about guilt. Thank you.
Thank you so much. I think we are out of time for any questions, unfortunately, because we got started a little bit late. But please find us during lunch or during any other session, and we would be so happy to talk to you about any of these issues. Thank you so much.